Friends, today's NRI Summit program from Los Angeles brought to you commercial free by listeners like you. Your generous donations make possible for us to stay commercial free, and today's show is pre-recorded. If you have a question for the guest, please send an email to nrisummit@gmail.com. We will follow up with the guest and find the answer for you. Thank you for your support.
Friends, this is Srihari Atluri, your host for today's show. We are on NRI Samai with Dr. Jayaprakash Narayan garu. He is National President of Lok Satta Party and also the founder. He was the ex-MLA of Kukatpalli, but very well known for his anti-corruption initiatives. He was also part of a lot of initiatives which are fruitful for India. Then today we will be discussing about especially about the judiciary system, that what it is right now, what are the issues, and what is being proposed by the government, what is in the new bill, and what are the limitations, what are the possibilities. Those are the topics we will be discussing. Friends, this is a live show. That means you can call into our studio 510-894-6747, or you can go to nrisummit.com/live and put your questions there. When you call in, please be very brief because we have limited time. Then after Jayaprakash Narayan garu, we'll also be talking with Shailesh Gandhi. He is the former Chief Information Commissioner for India. Friends, we have with us Dr. JP garu right now. Dr. JP garu, thanks for joining and welcome to NRI Samai.
My pleasure. Thank you very much for having me.
Sir, jumping right into the topic of judiciary reforms, could you tell us maybe a couple of issues that we are facing right now with the current system? What are the main issues, especially what are people suffering with the current system?
Srihari, this whole proposal to have a jurisdiction emanated from Lok Satta. We constituted a committee with three eminent jurists of the country. They are the three greatest living jurists, and one of them is no more with us, unfortunately. But they are the three greatest living jurists of the past generation in India. And that is Justice M. N. Venkateswaraya, former Chief Justice of India, late Justice Jaya, another former Chief Justice, Justice V.R. Krishna Iyer. Almost anybody who has any knowledge of Indian judiciary will acknowledge these three as the greatest jurists in the past 30-40 years. They have a wide variety of backgrounds. They are not unanimous on everything, but their integrity, commitment to judicial independence, and their commitment to the country cannot be questioned. They came together to come up with this proposal. The reason why we came up with this proposal is that we require a viable, democratic, and accountable mechanism to appoint judges of higher courts. Until now, India is the only country in the democratic world where neither the legislature nor the executive have any role at all, any say at all in appointing judges to the higher courts. It's almost like a mullah raj. Nowhere in democratic world does a branch of government appoint itself. In democracies, either you have to have popular sanction by elections, or you have to have legislative sanction, or the legitimate government elected must have the role in decision making. If none of these things happen, we're no longer a democracy. Because we started hating politicians in this country for a long time, we started also believing that unelected institutions are the best solution to the country. Yes, of course, we require unelected institutions, but judges appointing themselves is a bad idea in principle. It's also a bad idea in practice. We have a lot of nepotism. We have, very sadly, a significant amount of corruption in higher judiciary in the country, and we have a great deal of incompetence in judiciary. And you will be surprised to know, those who are not familiar, despite judges having the power to appoint themselves, there are a significant number of vacancies in the country in the higher courts. And there is a large number of very corrupt people appointed to the highest court also in the country. And it's time that we change it. And even the judges who actually gave a judgment asking for this Collegium system, for instance, Justice Jaya was the man who wrote the initial judgment on the so-called judges' case about this appointment of judges. But even he understood. At the time, Venkateswaraya was the Chief Justice. But both of them understood that when their intentions were sound, they did a lot of damage to the judiciary. So basically, this proposal is talking about a commission comprising of 3 Supreme Court judges, the Chief Justice and 2 senior most judges. That means 50% are actually Supreme Court sitting judges. 2 eminent persons nominated again by the Chief Justice of India, by the Prime Minister of India, and the opposition leader, the 3 of them put together. Again, the government has only 1 out of 3. 1 is an opposition leader, 1 is Chief Justice again. And only 1 member from the government, that is the Law Minister. The 6 of them will constitute the National Judicial Appointment Commission, and they will have to make a recommendation with at least 5 members, with at least, even if 2 members oppose it, it cannot go through. So basically the idea is there must be a broad consensus. And just because you have a majority, you cannot overrule somebody else and appoint an unworthy person. In the Thomas case, for instance, of the CVC appointment, Chief Vigilance Commissioner of India, Central Vigilance Commissioner of India, the majority, the Prime Minister and the Finance Minister then at the time, or I think Home Minister at the time, Chidambaram, they both overruled the minority, the opposition leader, despite opposition leader making strong objections, valid objections based on evidence. The Supreme Court correctly said you can't simply go by majority when there is a valid objection. So the idea is that there must be a consensus, and if there is a valid objection backed by some evidence, then you must ignore the candidate. I think it's only one the salutary thing. You can always think of a slightly better model, but this is a consensus, and they've also included the opposition leader in this selection committee. I think this bill must pass. And there is a likelihood of a constitutional change. In a self-serving mode, the Supreme Court may say it's unconstitutional, which is rubbish. What's happening today is plainly unconstitutional, patently unconstitutional. Many of the listeners may not be aware. This was debated in the Constituent Assembly in the country. And at the time, some people did suggest the concurrence of the Chief Justice of India for appointment of judges. But Constitutional Assembly after examination, after a great deal of debate, said no, nothing doing. That's not right. There was also another proposal that appointment was approved by 2/3 of the Rajya Sabha, the upper house. And the Constituent Assembly felt it would be too politicized, therefore that also is out. Came up with appointment by the government in concurrence, not in consultation with the Chief Justice, which has now been changed to only by the Collegium. More or less they have the final say. That's what the Supreme Court judgment has done. This present Constitutional Amendment, 121st Amendment, merely it eliminates done in the past 20 years or so on account of this judgment. So it's a good thing. There are people who will say, no, it's bad, we must go back to the practice of Collegium. But democracy, let me be very frank about that. That becomes very self-serving and dangerous. We have the integrity of the Supreme Court, credibility of the Supreme Court. If the Supreme Court is seen to be self-serving, if it is seen to have a lot of incompetent and corrupt people, and if it's seen to be transcribing its jurisdiction, soon to be usurping jurisdiction of other branches, the court will lose credibility and India will be in danger. I'll only make this one comment, Srihari. Look at Pakistan right now. There is an elected government in place, and by all accounts, the election was as free as is possible in the Indian subcontinent, with Nawaz Sharif as Prime Minister. Now, Imran Khan and this Qadri, they just go and launch a demonstration, say you resign. And there is a marpeat. If you use force, there will be a lot of bloodshed. If you don't use force, the constitutional elected government is paralyzed. And the Supreme Court, which actually earlier literally dismissed the Prime Ministers in the last government, now quietly washed its hands off and said, no, we will not intervene. This is exactly what the danger is. The court must intervene when it is really necessary in countries like India or Indian subcontinent, on matters like reservation, on Hindu-Muslim issues, some of the grand issues where there is no political solution possible. If the court intervenes everywhere, the court loses authority and the ability to intervene when actually India's future warrants it. And therefore, this is not a minor issue, though it's a constitutional issue and ordinary people are mostly unaware and don't care. It is a fundamental issue for the nation's survival in the long term. That's why we pursued it vigorously. And I'm happy for one that this has now become at least a bill that's going to the state assemblies, because the parliament, both houses are approved by 2/3 majority. And the state assemblies, half of them will have to approve. Hopefully it will be approved in the next few weeks. And it will become a constitutional amendment.
Sir, Hemant Potla from Delhi is asking, I think this is one of the concerns that most people are having, as you already acknowledged. He says, with the Judicial Reforms Bill, is there any threat of political influence on judiciary? Is judiciary's independence at stake? what could be the consequences and remedies if there are any?
First of all, India has a glorious record of judicial independence. Nobody even remotely attempts to intervene into judicial functioning. In fact, I can tell you very confidently, leaders across the parties, they acknowledge privately, not only publicly, that it's important to respect Supreme Court's independence and its primacy in matters judicial. Because they realize that India is a very fractious country, and unless there is an umpire, you remember the Babri Masjid case? After all that strife, ultimately when Allahabad High Court gave a judgment, the whole nation simply accepted it quietly. And the matter is now carried to Supreme Court. Again, Supreme Court, whatever it says, the country will accept it. The people and the political parties have the wisdom to realize that on matters like that, on very contentious issues, it is best to leave the matter to the Supreme Court. Therefore, judicial independence is absolutely, it is an integral part of our constitution, and the practice as well as the principle both ensure it will be there. Judiciary as well as Election Commission. Even Election Commission, let's resort to an institution. Take the United States Election Commission. Nobody cares for that. You haven't even heard about it. Though there is actually a Federal Election Commission. But Indian Election Commission is a very awesome presence. It's not a Supreme Court. It doesn't have the constitutional powers of Supreme Court. And yet, it is respected. So I think there is no reason to fear the judicial independence will be thwarted. Now, the second thing, will there be political interference in the judicial independence? Not at all. There is only one politician, the law minister of the country. Two eminent persons have been appointed by a committee of Chief Justice, Prime Minister and Opposition Leader. If you can't trust these three people, then India is anyway finished. This notion that you can't trust the Prime Minister of India, you can't trust the Opposition Leader, is a very farcical notion. It's a very dangerous anti-democratic notion. If you come that far, India has no future as a democracy. Therefore, these fears are totally exaggerated, sometimes self-serving, and a lot of people, they're parading these views because they're anti-political approach, because they basically hate politics. That's what we need. We want to improve politics. We want to transform politics. We want to make politics noble, but not debase politics or delegitimize politics or create non-political institutions which enjoy supremacy. That's exactly what's happening in Pakistan. Politicians are hated, and therefore the army is now the supreme authority in the country. That's not what any Indian wants. Therefore, there's no reason to fear this. It's a very practical, balanced one. In my judgment, the political parties are extremely balanced and rational and very patient on this issue. They took a lot of heat and a lot of humiliation. Despite that, they acted with a great deal of calm and dignity. And there is impressive consensus across the spectrum from left to right, opposition to ruling party. That itself shows why it's a vital issue in the country. I don't see any legitimate grounds for these fears.
Thank you, sir. Sashi from Sunnyvale, California, he's asking, is it possible to have a bench of at least 3 to 5 judges all the time whenever it involves cases against any corporate or a person with power?
The practice so far is, typically the Supreme Court will all the benches, and the constitutional bench will always have at least 3 members, sometimes 5 or 7, 9, 11. And the convention is that if the constitutional matters are decided by a bench, let's say of a 7 judges strength, then to examine that, the bench must be a larger one, a 9 judges bench or 11 judges bench, that sort of a thing. But merely because it's a corporate matter, it's unlikely to have a 5-judge bench. Typically, they do have 3-judge benches if they are big enough issues. 3 judges are common. We must understand that already Indian Supreme Court is overburdened. Take the American Supreme Court, you only have 9 judges. And all the 9 judges, there's 1 bench. And annually, American Supreme Court hears only about 100 to 120 cases. Most people are not aware of this. Thousands of people may approach them, but they only take up a small number of cases. And if some cases are not taken up in the calendar year, then that's it. The case is never taken up at all. Another day, after 10 years, it will come again. Because next year again, a fresh calendar begins. And therefore, the Supreme Court's majesty is now protected. It's only involved in the constitutional matters, whereas India's Supreme Court has become a civil court, a criminal court, an appellate court, all kinds of things. And it's overburdened. It's absurd to really think of a bench clearing 60 or 70 cases a day sometimes. This is not the way an apex court, a constitutional court in the country should function. We must not overburden the Supreme Court. And Supreme Court also is taking up too much of executive functioning, which is again unconstitutional in my view. Of course, nobody has given the court the power to execute decisions. Their rules to adjudicate. They have created so many so-called empowered committees, and they appoint people of their choice, and sometimes empowered committees act arbitrarily, and there are also instances of serious allegations of corruption there. So no, let's not think that the problems of India can be solved by one Supreme Court or one Prime Minister or one High Court or one Election Commission. This is a very facile way of looking at things. We have to build a certain network of institutions which are accountable, and nobody should be all-powerful, and nobody should be denied a say in the matter. We haven't done that, and therefore we can't really have a law or a rule saying that every corporate matter should be decided by a large bench.
Friends, NRI Samay is a non-profit independent alternate media from Los Angeles, USA, which brings positive stories from grassroots activists from all corners of India and across the world. NRI Samay does not rely on corporate funding, and our shows are commercial free. We only rely on your donations. Corporate funded media is driven by the TRP rating, and profits are blurring the distinction between news and entertainment. Why do our news channels talk so much about cricket, movies, accidents, popular figures' personal lives, babies of heroines, gossips, etc., while they should be covering the struggles of people, inequality in our society, rural issues, and border security issues? Why did our media raise some corruption crusaders to the sky on one day and shut them off completely when graft charges were raised on those corporate sponsors? Media relies so much on the corporate funding and government blessings that they cannot report independently. NRI Samay is different. We don't accept funds from any corporations, and hence our shows are commercial free. We completely rely on donations from you. Please consider donating to NRI Samay, and please go to nrisamay.com and donate generously. This is the only way together that we can continue NRI Samay. All donations are kept transparent on nrisamay.com. And if you have any questions, please write to nrisamay@gmail.com.
Absolutely, sir. Sripal Sama, he's from Des Moines, Iowa. I think this is a very important question. A lot of the people on the ground are feeling. He says that he's aware of an incident where there is a land dispute going on for several years. Then finally the judge approaches his friend's family and says, give me some bribe and, we'll get over this one. So he's saying, how do we get over these kind of situations when judge himself is corrupt? And that's a problem with the current system. And he's also citing the example of Gali Janardhan Reddy, and then he says, the Judiciary Commission is at the high level, but what about the district level and taluka level courts?
Absolutely. Sripal is absolutely right. Even in the highest court, there were serious allegations. I'm sorry to say this publicly. In the high court, there are plenty of judges whose notoriety is very well known. By reputation, you ask any lawyer, any serious litigant, they would tell you what's happening. So to pretend that these judges in India are lily-white would be nonsensical. There is a serious problem. Therefore, National Judicial Commission or Judicial Appointments Commission is only one small step, an important step. We also have to ensure that there is an all-India judicial service so that the quality of people coming in, at least at the initial stage, will be high, like the IAS and IPS. But even more important, as I said rightly, at the higher court level, India never applied the Article 124 provisions of impeachment of judges. In America, regularly federal officials and judges are impeached and removed. Supreme Court level, it never happened, but at other levels, impeachment and removal is pretty common. In India, it never happened so far. Only one judge actually was forced to resign before the matter went up to the other house. Therefore, in India, we must be willing to resort to that in a non-partisan manner. That's the reason why we actually also recommended that the same Judicial Appointments Commission must be empowered through a due process to go into complaints against judges of higher courts. And once there is a recommendation made by, let's say, 2/3 of the members, it must be binding on the president to remove them. No further ado. I don't think the impeachment process will work in India. It has not worked so far. And at the lower courts, the subordinate judges, as we call in India, the respective high courts have all the powers under Article 235, I think. In some cases like Maharashtra earlier, Rajasthan, West Bengal to some extent. The proactive high courts and the good chief justices did remove a lot of deadwood because they have supreme powers. They can even remove the judges after due process, and after only the high court itself removes, who is going to stop it subsequently? It's unlikely the Supreme Court will intervene. So they really have enormous powers. But oftentimes they are not really utilized. It's time that there's pressure on the high courts to utilize them. It's not proper for us to take away the powers of the high court or subordinate judiciary. But we must ensure that the high courts actually function. Even the Supreme Court has no powers there, only high court has powers. But Supreme Court certainly, in exercise of judicial jurisdiction, can direct the high courts to perform their functions. I think it's high time that we looked at judicial corruption even at the subordinate courts level very seriously. There is a huge problem. There's no point pushing it under the carpet. Madhu Trehan, the noted journalist from Delhi, when she published merely findings of a survey among the cognoscenti, the lawyers, about the integrity of judiciary had the temerity to simply shut down that newspaper. They imposed censorship. They give us a lot of lectures about freedom of speech and about constitutional freedoms and guarantees when it comes to others. When it comes to themselves, they have a self-serving approach. We cannot allow that. No institution in the country, nobody should be allowed to be above law. They're all ordinary mortals. They're prone to error. While we respect them as institutions, nobody should be taken at face value as God, and they must be held to account. And I think the experience of the past 20 years teaches us, particularly about judiciary.
Often we hear about content to the court orders, which means there is a court order and there is a judgment and somebody says, we don't like it. Then they say there is a court content and there is a... So in this scenario, it's very tight situation, right, sir? I mean, if it is a politician, we can say whatever we want. But when it goes to a court order, I think it's very restricted, like you are saying. So can you comment on this situation?
Srihari, contempt powers of the judiciary, they exist in many countries. United States has them. United States, even ordinary judges can actually impose penalties. In India, ordinary judges cannot do it. Only high court can impose the penalties. The ordinary judges put to the high court. So it's not the contempt power that is a problem. And also, mere of a judgment is not contempt. We are perfectly free to criticize a judgment on valid grounds, either on facts or on logic. We can say this judgment is wrong. I openly say, for instance, that the Supreme Court judgment on judges' appointment is constitutionally. That is my right to say so. That's my judgment. And therefore, that cannot be a matter of contempt. What is contempt is if I say that the judges are bought in giving this judgment, or their judgment is nullified, or they are prejudiced, then they are undermining the judicial stage and their credibility. That is a matter of contempt. There's a distinction. Criticism because they are wrong is not a matter for contempt. Except that any criticism means that there is contempt, then we are saying that judges are gods and it is rubbish. They're ordinary mortals, they're very much fallible. We respect the institution, but we criticize them. Because in India we don't understand these subtle distinctions, we really are petrified. That's unnecessary. There must be a healthy debate about Supreme Court judgments or High Court judgments. But at the same time, we must make sure that the independence of judiciary as well as its credibility are all protected. In fact, Lok Sabha has been working on this National Judicial Appointments Commission in order to protect the judiciary's independence and credibility. Because nations like India are still fragile, still fractious. There are too many polarities, caste, region, religion, all kinds of things, or reservations, this, that, everything. Unless the Supreme Court retains its authority and credibility, the nation is in danger. I have to use the Pakistan example. Therefore, any criticism which is not meant to undermine the prestige of the judiciary or which imputes motives, but which actually goes into facts and logic is perfectly legitimate and nobody can hold you in contempt. In India, unfortunately, like everything else, there's some tendency to use it arbitrarily or to threaten it. Sometimes they themselves may not be aware of the limitations of their power or a larger understanding of the constitutional freedoms and democratic restraints. But that's a different question altogether.
Okay, thank you, sir. Sir, Sambireddy from Hyderabad is asking, what is the selection process before 1998 for judges in India? I think because it was not always a Collegium system. It used to be more, there was a...
No, under the Constitution, as I said, The Constitution merely says the President shall appoint in consultation with, in consultation with the Chief Justice of India. The procedure evolved is, in respect to the High Court judges, the High Court Chief Justice will send proposals to the Governor. Similarly, the Chief Minister will send proposals to the Governor. Then there may be a formal consultation among these people between the Chief Justice and the Chief Minister and the Governor. After a view is taken by all of them together, it will take months, this consultation. I've seen it very closely. Then it is referred to the Government of India. It goes to the Law Ministry as well as to Chief Justice of India. It went to before the Supreme Court judgment. Then the Law Ministry initiates the proposal in Government of India. The Chief Justice's views are taken. After examining the views with their comments and their recommendation, the matter finally goes through the Prime Minister of India to the President. The President is the person to give the warrant of appointment, as we call it. So that was the process followed. Certainly, there were cases where there was political influence, and it will be foolish to deny that. But at the same time, the appointment of judges in those days also was pretty good. There were many cases where outstanding people were appointed. Men like Justice Jayaprakash, for instance, Justice Koka Subbarao, and many other eminent judges, Justice Amin Venkatachala himself, Justice Jaya himself. How did they all come up? They didn't come through the collegial system. They came through that old system. Justice V.R. Krishnaiyer, he was actually a politician. Many people may not be aware. Krishnaiyer was a law minister in Kerala. Then he resigned and then became a High Court judge, then became Supreme Court judge, one of India's greatest jurists of all time, despite his partisan political past. So men of such caliber, there were very few women, unfortunately, who were chosen. They could be selected. They were, of course, flaws in that. Therefore, some kind of a system like the Judicial Appointments Commission today, involving the legislature, the opposition, and the judiciary, and doing it in a collegial manner is very welcome. But it cannot be judiciary's private prerogative. Judiciary is not the private property of the incumbent judges. If we accept that notion, MPs can choose their successors, MLAs can choose their successors, ministers and prime ministers can choose their successors. That's what these fellows want. That's what we do not want in a democracy. Therefore, it's laughable. It's democratically absurd to think that any institution can choose itself. It is like permanent priesthood. The priest choosing their successors. It's like a mullah raj. That cannot be allowed. It's fundamentally wrong in the constitutional scheme, and this has to be corrected. There is a possibility that the Supreme Court will hold it unconstitutional because in India people don't understand these nuances. In a self-serving mode, they may say that this is a fit case where the Parliament should stand firm and put the court in its place. Because Indian Supreme Court has certainly crossed the line. It has transgressed into executive jurisdiction in a variety of areas. It's best in the country's interest and judiciary's interest that the Supreme Court limits itself to what it has to do and do it well.
Thank you, sir. Sivaram Krishna Boddu from London, he's asking you to give a comparison between the selection appointment committee of the Lokpal versus the judiciary system, and also he's asking about how to solve the tussle between RTI commissioners and the judiciary. Maybe he meant the Lokpal and the judiciary, but I'll let you answer.
Okay. The broader principle that is now applied in the NJAC was also applied in the Lokpal appointment. There is a body, the Prime Minister, the opposition leader, Justice of India, they all sit together, and then a certain committee is constituted, and the selection is made. So, the same principle, that no organ must have the supreme power, and there must be a consultative process involving both the legislative branch, that means the ruling party and opposition, and the judiciary. The same principle adopted also in case of the Information Commission. That's actually the first case when we did that. At the time, I insisted on having the Supreme Court Chief Justice. Dr. Manmohan Singh as Prime Minister, he brought to my notice that, look, already there are difficulties in dealing with judiciary, therefore please don't insist on that. And therefore, at the time, we instead of the Chief Justice of the Supreme Court, the government went in for the Prime Minister, a Minister, and the opposition leader. Instant opposition is very much there, but not the Chief Justice. But otherwise, my initial draft on the Right to Information Act was, it incorporated Chief Justice of India. So the past 10-15 years, many of us have come to the view that there must be a high-powered body to appoint all these high constitutional or statutory bodies. But many people may not be aware. After Supreme Court, the most respected institution in India is the Election Commission. The Election Commission is appointed entirely by the government of the day. So CAG, Comptroller General, entirely by the government of the day. All these must change. In fact, there must be some kind of a process for all the constitutional authorities to appoint them by this kind of a collective body, not merely the government of the day. Government must definitely have a significant say. We cannot deny the government, so that will be wrong democratically. But government cannot make it a partisan affair. You see, for instance, Naveen Chawla being appointed as Chief Election Commissioner of India. He had a track record of violating the Constitution during emergency. And he was not really fit to be Chief Election Commissioner of India. And yet, because the government had supreme authority to do whatever it pleased, there was no transparent process, they could appoint their own friends or whomever they like without reference to larger scheme of things. Therefore, it is high time that something like NJAC or the Selection Committee for Lokpal or the Information Commission, something like that is applicable to all the constitutional appointments in the country. As far as the Supreme Court's, I really haven't seen the court's order, I've only seen the headlines. I do not know what exactly the court said. If the court is saying that you cannot hold up Lokpal's appointment because the opposition leader's position is vacant, it's a reasonable position. Therefore, it's now for the Parliament and the government to come up with an answer. Either say, even if we don't give the leader of the largest party in opposition in Parliament, the opposition leader status formally, we will still involve him in the consultation process. That's one way of doing it, and therefore frame the rules accordingly. The other way is actually amend the law to provide for not merely the opposition leader, in the absence of a leader of opposition, the leader of the largest party in opposition, that's in Parliament. And there are quite a few laws where such a provision already exists. It's not new. Therefore, it's a minor thing, relatively speaking. The Supreme Court, no. Unfortunately, everybody wants to dramatize things to get headlines in newspapers. A mild issue is blown out of proportion. It can be easily resolved. This problem can be easily solved.
Absolutely. The question that you just answered, actually, it was from Siddharth M, Hyderabad. But the other question, which is, this is from Sivaram Krishna Boddu from London. So do you want to respond to that? So I think he's talking about a potential conflict between Lokpal giving a judgment versus Judiciary giving a judgment. Do you see that possible?
No. I say under the Indian Constitution, the Supreme Court on matters judicial is final. No matter who gives a judgment, Lokpal or anybody, the Supreme Court's verdict is final under the Constitution, Article 72 and, I'm sorry, offhand I'm not able to mention the articles. In case of High Court, it's on Article 226. So there's no problem at all. Even if a former Chief Justice of India is a Lokpal or the chairman of Lokpal, still Supreme Court's jurisdiction is final. But again, the courts also must act with restraint. In the United States, for instance, during the FDR's time, the New Deal's time, the Supreme Court shut down many legislations which were desperately needed for the country in time of recession, actually a depression. The nation was in a severe economic crisis, but the court was asserting its authority. And when the matter was carried to the president, he said, look, in matters judicial, judiciary is supreme. In matters executive, I am supreme. Nobody is supreme in all matters. Nobody elected the Supreme Court of India to be supreme in matters executive. That's what people outside judiciary must understand. We must understand, because the word supreme, we must not think the Supreme Court is supreme. It merely is supreme in matters judicial, in adjudication, period. No more, no less. Not in executive management, not in constitutional jurisdiction of other authorities in the country. But in matters judicial, certainly their word is the last word, even if I don't agree. I may not always agree with their judgment, but somebody must have the last word. And later on, if my argument has greater value, if I can persuade the jurists of the country, I will always have a chance to go for the Supreme Court. In America, there are many issues unresolved. The gun control issue, the federal funding of elections issue, or the funding restraints issue, or the abortion issue. These issues are debated endlessly. At a point of time, there is a finality, but doesn't mean that there's a last word on the subject. Again, in some other form, the matter may go to court. The court may, depending on the circumstances prevailing, give a slightly more nuanced or different ruling. And then that becomes the law of the land as far as the courts are concerned for the time being. This is the way the case law develops anywhere in the world, because we're not gods. And society is not immutable. Society always changes. What appeared terrible 10 years ago would be good today. What appeared good then would be bad today. Remember the Taney judgment, the Taney Supreme Court judgment? That's what led to the Civil War in the United States. Because Supreme Court then did not give the black men the rights, African Americans the rights. And that led to the Civil War. So it's not that the courts do not have, they do. But because there is a continuous process of review, revision, and the matter being heard again and again and again in some form or the other, case law evolves and constitutions evolve, the society evolves. And judges must understand with humility that they themselves change their views and they proved to be wrong. For instance, in India, during emergency, the Supreme Court role was pretty dismal. They failed to protect the civil liberties in the country. They actually said that any uniformed constable can shoot and kill anybody in India and there is no judicial recourse, which is an obnoxious judgment. Subsequently, a Supreme Court Chief Justice, Chandrachud, he publicly apologized for that. He was the man who wrote the judgment, for instance. So we must not assume that just because there is a Supreme Court or Prime Minister or Parliament, anybody is absolute or supreme. But we must at the same time respect their authority in a certain sphere for the time being.
Most of the people in India, especially the poor and the middle class, they are afraid to even go to a police station or file a case, and even afraid of the courts because they are not sure when their case is heard, or how long it will take, or how much it will cost for the lawyers, and how much time.
You are absolutely right, Hari. You are absolutely right. See, that's why ultimately this debate about Supreme Court and High Court judges' appointment is, in a larger sense, a marginal issue. It's of course a grand constitutional issue about jurisdiction, balance, separation of powers, and balance among institutions. But it's not a matter of justice delivery. India is appallingly bad in justice delivery and rule of law. We must first acknowledge that. The way the law is applied by the police forces, the way the police is under thumb of the politicians, the judicial failures we have discussed so far, the judicial delays, even if there is no corruption or incompetence otherwise, tremendous delays. Everything is lawyer-centered, not the litigant-centered or the citizen-centered. Things are pretty appalling. India has 30 million cases pending in courts, the highest number in the world. 2/3 of them are criminal cases. Typically, in advanced societies, civil cases will be 2/3. Criminal cases pending will be only 1/3 at the most. We have 2/3 criminal cases pending. Therefore, rough and ready justice has become the norm. There is actually a market demand for criminals in India for want of justice through normal judicial process. The Gundas have arisen in the country because they have become the undeclared judges in the country. And they're also, because of the clout they acquired and the money they made, they're also becoming future politicians. So the failure of judiciary or justice system of rule of law has profound consequences to the country. We have to set it right. And this is a small thing, what we're discussing so far, NJAC, etc. But a lot more needs to be done. That's why Lok Satta was privileged to fight for and get one very good law in 2009 enacted. That was the law on local courts, what's called Gram Nyayalayas Act. If indeed that law is implemented, we would have had about 4,000 or 5,000 courts in India at the lower level, capable of giving quick judgments through a summary process, but as an independent, as an integral part of independent justice system under the high courts of the state concerned. It's part of justice system. And yet, the high courts are very slow to accept this and utilize this. They have become actual obstacles in many cases. Whereas 5,000 courts should have been established by now, so far only 172 courts are established. So no, ultimately whatever the courts say or the legal profession says, there's no deep commitment to really rendering justice. It's all lawyer-centered. They are callous about the rights of our citizens, particularly the poorest of the poor. When the courts are weak, when judicial delays are there, or when justice is very expensive, accessing justice is very difficult, the people who are going to be most hurt are the poorest in the country. Because the fellows with money, they can ride their way. The fellows with political power, they have enough influence. It is the poorest people who actually suffer when the rights are violated. And the whole system, the police or judiciary, is unmindful of that, and we have to have a massive reform everywhere. A massive reform everywhere. What we're discussing is only a small little step. One of the reasons why we're asking for All India Judicial Service, very much like IAS, IPSC, is in the hope that tens of thousands of young people will compete for these prestigious offices because there is a glamour for All India services. We get the best quality. Therefore, competence is there at least at the point of entry. If you protect that later, quality of judges will be high. And even that, sadly, the Supreme Court and High Courts oftentimes resist. Earlier, Supreme Court itself said repeatedly it's required. It is there in the Constitution. Who are they to say or not to say? Article 3 of the Constitution specifically provides for Indian judicial service. And yet the courts have the temerity to say, no, we should not have it. As if it's the private property of these people. This is plain wrong. We cannot allow anybody to dictate terms to the country. The country must be run democratically and rationally, not at the whims of anybody, no matter how exalted the branch of government is. I'm using harsh words sometimes, but I think you all must understand why I'm saying this. We have to really safeguard our democracy. Far too many things are wrong in this country, and far too many things are too many people are self-serving, and we're all only too happy to blame the politicians for all these. Of course, politicians are bad in many respects, but we're only too happy to blame them and pretend that that's the only problem in the country. The crisis of India is much more complex. It's not merely that you should put all the politicians in one room and then shoot them down like in a B-grade Hindi film. That's not the solution to India's problems.
Absolutely, sir. I will ask the same question to Shailesh Gandhi later in this show also, but I would like to ask this question. You just mentioned that NJAC is maybe only the beginning of it, but if you have to sum it up and maybe into 2 or 3 points, what are the next steps that we should look for in the judiciary reforms?
No, very quickly, we require Indian Judicial Service for recruitment to higher judiciary, but it's about the judiciary at higher level so that they become the recruiting pool for High Courts and Supreme Court. 2, we require, as somebody suggested, firm action against the erring subordinate court judges, and also we require to give powers of removal of Supreme Court, High Court judges to a high-powered body rather than a 2/3 majority, because that's unlikely to ever happen in this country. 3, we have to make sure that the number of courts in India is much larger. India has only 10 judges per million population. In a country of this size, we only have about 1,000 or so judges, and in that there are about 1,500 or 2,000 vacancies. We only have about 10,000 or so judges. Whereas most of the developed world and civilized world has about 100 judges per million population. We must at least enhance our strength 3 to 5 times if we want to give justice. In a modern society, if you want to give justice, there is a cost involved. If you want to be parsimonious about this cost of justice delivery, then, as I said before, you will only have a Gunda Raj in the country, a lawless society where neither economic growth nor freedom are secure. Then, we require to also make justice accessible and inexpensive, not only the number of judges. That's why, for a large number of simple cases, you must have a summary judgment, judicial process, not non-judicial process, as an integral part of independent justice system. In the US, for instance, roughly 100 billion cases are disposed of annually in the so-called people's courts, from traffic offences to simple assaults and drunken behavior to all kinds of things. Millions of cases are disposed of in 2 minutes, 5 minutes, because common sense and an understanding of facts on the spot and the summary judgment is enough. You don't have to go into elaborate written or oral arguments and lots of evidence, etc. We're simply wasting our time. That's the kind of thing required so that for simple cases, justice is available, particularly cases like women's harassment. We all the time talk about rape and murder of women. These are the last offences. The first offences are the eve-teasing, harassment in buses and offices, touching them without permission, using abusive or vulgar words, innuendo. And women, day in and day out, face this, and there's no recourse. They all swallow this in silence, this insult, this humiliation. They shed silent tears because nobody bothers about that. And this becomes part of their life. It's an insult to the country. Once we allow this kind of behavior, eventually extreme violence against women, rape, brutality, murder, this becomes all too common. Therefore, all these cases at a lower level, the much less serious offences, can be easily addressed initially in a variety of innovative ways through these mechanisms, and we can give safety to people. So there are many ways of doing it, and none of these things is new. India had honorary magistrates earlier. We removed that. There are many good practices earlier. We removed all those practices, and we created in every class, whether it's bureaucracy, whether it's politicians or judiciary, a self-centered group of people who don't want any fundamental change. There was a time in bureaucracy when a clerk could have become a collector if it was good enough. Today we created a third-rate system where No matter how competent you are, you cannot rise. No matter how useless you are, you cannot be removed. This is not the way to govern a society. We must build a society where competence, integrity, merit, all these things matter.
Absolutely, sir. Sir, we are towards the end of the interview. I would just like to read out what Pawan Kumar Machikanti is saying. He says, congratulations for everyone to have achieved until this date, sir. One of the very rare inspirations for this country. Just want to say this. But apart from him, there are a lot of folks who are sending us messages that they're congratulating and thanking you, Dr. JP, sir, for whatever you have done in this area. With that, I would like to thank you very much for taking this time.
Thank you. The pleasure is mine. There's a lot more to be done. Indian Judicial Service is now on the annual. Again, we made this recommendation. The same committee recommended that. I hope that will happen too. Local courts, as I said earlier, we already achieved it, but it's not implemented. We have to fight for that. And in other sectors too, a lot more needs to be done brick by brick, and we will do that. And I'm grateful to you for your engagement, because unless the intelligent Indians are deeply involved, not on a superficial level, but really understanding the nuances and in a balanced way, try and bring about improvement of institutions, the country cannot be better off. Mere shouting and abusing and scolding those in office or going onto the streets, and all this is dramatic, nice, but it will not change the country. Ultimately, it's a small group of thoughtful, committed individuals that changes the world, as Margaret Mead said, and that's what we all should set out to accomplish. And I'm sure together we can make much more changes, many more changes happen in the next 5 to 10 years. I wish you all the very best. Thank you.
Thank you, sir. You have a good night.
Bye-bye.
Friends, that was Dr. JP, sir. He was explaining about the judiciary system, and we want to thank you for joining this and also actively participating with a lot of interesting questions. Please stay tuned. Next, we'll have Dr. Shailesh Gandhi. He is the former Chief Information Commissioner of India. He will be talking about the same topic. You will hear a different perspective on this one, and also because he will go into little more details about the statistics, the numbers, and so forth. He has recently written an article which was published in Hindu, so he'll go into that as well, and he will elaborate on those things. He'll especially be talking about the delays, and that has the main concern that we are following. But he'll also touch base on few other issues. Friends, I want to remind you that the NRI Samai is a social radio. It's an independent non-profit radio. I say it independent because we are not dependent on any corporate funding. We only rely on whatever funding we receive from the listeners like you. There is no too small or too large amount that you can donate. You can donate whatever you like. You just go to nrisamai.com. There's a button for donate, and you can donate money there. And we also encourage people to help us in other ways. You can always write an email if you are interested to nrisamai@gmail.com. Friends, next we'll be listening to Shailesh Gandhi. Friends, welcome to NRI Samai. This is Srihari, your host for today's show. We have with us Shailesh Gandhi ji. He was the former Chief Information Commissioner of India, and we are going to talk about the Judiciary Reforms Bill and what is the need for it and what's in it. Shailesh ji, welcome to NRI Samai.
Hello.
I would like to thank you for taking this time and spending it with us today.
No, it's always a pleasure talking to you.
Thank you, sir. So to begin with, I would like to ask about what are the issues we are facing as of now with the judiciary system we have in India. The major ones on the top of...
Okay. So what has been taken up politically in the judicial accountability bills, etc., is about the appointments of the judiciary which are non-opaque, and how to deal with corruption complaints or complaints against the judiciary. That is the current bills before Parliament. Okay. However, I do believe that the biggest issue is that there is no timelines to the time it takes to get justice, particularly if you are poor. The system theoretically talks of a justice system, which is a fiction. If you are rich, you have access to the justice system and you can hope to get it in some reasonable time. But if you are not very rich and not very powerful, you can be on a long wait, and you can actually be tortured by this system.
Yeah, absolutely. And I think that's where the common people feel the pinch. Just they don't get justice. That means justice is denied. At least they don't get.
No, there is no justice. I call it an injustice system.
Yeah. Yeah, I think the common people, they're not too worried about how the appointments are made, but they just want their cases to be heard.
That's right.
Yeah.
And that is not being addressed, which is very unfortunate. I mean, neither nation nor media nor citizens are looking at this. In India, it's been almost as if it's given up. I mean, it's assumed that it can't happen.
Yeah. So is it mainly because of the current system, which is completely in the judges' hands, or is it because there is a lack of political will? Because we heard Prime Minister Narayan Modi ji, he was talking about 1 year time limit to wrap up all the cases on politicians, but then we heard from Supreme Court that it's not possible.
On this, I think the Supreme Court is right. You see, the whole concept of, we got so used to what we call fast-tracking various things. Okay. If there are rape cases, fast-track them. Cases against politicians, fast-track them. Something else, fast-track it. Consequently, the ordinary man keeps getting pushed back. When you say fast-track, what does it mean? You take somebody out of the queue. Okay. So the others suffer. I mean, what kind of a justice system is this? So on that, my own feeling is the Chief Justice is right. We should stop this whole concept of fast-tracking A, B, and C, because when you talk of fast-tracking, it means somebody is pushed behind.
Absolutely.
Which is not fair at all.
Yeah, it's injustice for somebody else. You want to fast-track somebody else, and somebody else is left behind, so which is injustice for them too.
That's right. My own view is that, see, this fundamental issue has been left aside by everybody, which is the most evident, and I don't know that you are aware, 65 to 70% of those in jails, people in jails, are under trials. That means they've not been convicted.
Yeah.
Only about 30 to 35% are convicts. To give you a comparative thing, in the US, 20% are about under trials.
Yeah, in US it's much faster. It can happen in a couple of months actually. Most of these cases. So yeah, we are not even close. And 65% of people they may not even have committed the crime, and they are just sitting in the jail, waiting for the next hearing. Right. Yeah, that's very bad. As you said, I think this is a biggest.
I don't know whether. And I have been to some of these courts. I'm not claiming extensive experience on this, but in a typical day, let's say in Bombay High Court, 40 to 80 cases will be listed, and decisions would be obtained in barely 5 or 6. All the rest, everybody comes, everybody goes back. The system is extremely wasteful.
Yeah.
And the normal story is it can't be done. I mean, I've heard Supreme Court judgments and other judgments also saying that we need 5 times the number of judges, we can't do it. I mean, somebody says we'll take 300 years to hear cases, which is that nobody's studying the issues and looking at it rationally.
Right. Yeah, if 60-70% of the cases go back every time, then that means that itself is a problem. It's not doesn't matter how many people you put there. Yeah.
It is 70 to 80, I am saying. Right. 70 to 90, it ranges somewhere in that region.
Yeah. As far as the current, what is being debated, so they are only talking about the appointments of it and the corruption within. So now it used to be the current system is that the judge has the power to appoint the next judge. But now it's going to be more. So it's distributed among the judges and also the politicians. Do you think this is a better system, or is it getting worse from your point of view?
I personally feel it should work slightly better than the current system. Because what has happened is, and there is a history to this, see, originally the executive used to pick the judges for the High Court and Supreme Court. Then, when Mrs. Gandhi came, she went to an extreme where she was appointing people because they agreed with her.
Yeah.
And in a very controversial and a very doubtfully argued case, the Supreme Court held that they have the right to appoint judges. Suddenly, everything was changed. I don't think that was the intention of the Constitution.
Yeah.
So now we have a collegium of 3 to 5 judges who will select. So it's a very close coterie, and there is no transparency as to why they are taking the decisions. Unfortunately, even in the new act that's been passed, there is no issue of transparency. It is just assumed that some wise people know what is best for the nation. All the rest are fools.
Yeah.
Whereas in US, as far as I am aware, I think even the appointments of judges is transparent. There is a process in existence.
Right. Yeah.
So this is just about deciding who in power can influence something.
So in the new NJC, I think that's what they're calling.
That's right.
You have the Prime Minister, you have the opposition leader, and you have the Law Minister, and then there are judges who will be involved. So it's a collective decision they're going to make for every appointment, right? Do you think this is more? This gives little more transparency than the accountability?
No. Even in this, there is no question of transparency. It's still going to be an extremely arbitrary exercise.
Yeah.
So my own view is that it is transparency that brings about democracy, transparency that brings about robust and fair systems. It's not a matter of whether you decide or I decide. If we have a proper process and system, it will deliver better by and large.
Right. And I think some of the concerns we are hearing are now it's all internal. There is no external. There is no executive power on it. So it's all judiciary who is deciding, which means it's an independent.
That's right.
Now the concern is we have a very bad political system. People don't have a good trust on it, and we are saying we are going to have politicians also influence. So people are a little worried about the political influence on appointing judges. I think they have their good reason.
No, the real truth is that the Indian nation has been subjugated by the judiciary. I mean, we've just come to accept that whatever judiciary says is good. We are not questioning.
Yeah.
By variety of devices, the judiciary has made itself look as if it's the best in the country.
Yeah.
It doesn't need to be questioned. It must not be questioned. In these circumstances, how bad or good the judiciary is, we really don't know. The real answer is that.
Yeah.
Relatively, the politician and the bureaucrat is at least criticized publicly.
Yeah.
By citizens, media, everybody. Okay? Judges are not even criticized, not even dissected publicly. I mean, very rare cases will it happen, extremely rare.
Yeah.
And therefore, we really do not know how good or bad the judiciary is.
Yeah, once in a while somebody says judiciary system is the worst in India, worse than political system. So, but we don't know.
It may not be. We don't know.
Right. We only hear, like you said, we heard about when Gali Janardhan Reddy was trying to bribe the judge for his bail,
right.
And that became a huge news. But that came out, but we don't know how much. And I guess there is no RTI in judiciary system, right? I'm not sure.
No, the RTI does apply to the judiciary, but in most cases they refuse to give information. And then you can only contest that in the courts.
Yeah.
So the courts either give a judgment against disclosure, or more often, even if there's a very strong case, they just keep it pending.
Yeah.
So what do you do, really?
Yeah. And in your article, I think you pulled a lot of numbers when you did some math. Would you like to elaborate on that, please?
I would love to. Let me explain. And therefore, you see, I took a look and said, how many judges do we require if we have to get time-bound justice? To me, that's fundamental.
Yeah.
Whether you get a good judgment or a bad judgment, you must get a judgment. Because human beings have finite lives.
Yeah.
The analysis I did, I have taken figures from the Supreme Court's website. They have figures for total number of cases, in fact split up state-wise and so on, of number of cases instituted in a quarter, number of cases disposed in a quarter, and number of cases pending each quarter. So I took the number of cases disposed each quarter by a particular court and divided it by 3 to come to monthly pendency. I mean, how much is the disposal per month? And the figure of pendency, I divided by this figure to get to number of months of pendency in each court. And this showed up a very phenomenal result. It shows that the average pendency in terms of number of months, if you take all cases as representative, is 9 months in the Supreme Court, 30 months in the High Courts, and 19 months in the lower courts.
I see.
Whereas the actual effect is huge. Okay. And just one more figure I'd like to highlight, which is there is always a continuous vacancy of about 15% in the Supreme Court, 30% in the High Courts, and over 20% for the lower courts. So on the one hand, judges say we don't have enough infrastructure, we don't have enough. They don't even fill up the available vacancies.
Yeah.
And I discussed this with one High Court judge, and very surprisingly, he said, "Oh, Mr. Gandhi, judges retire."
Right.
As if a new principle had been discovered.
Yeah. Of
The
course,
fact
they
that
retire
judges
and
retire
judges
is
have to
known.
hire this. Right.
No, and you know when the judge is going to retire.
Right.
Because it's age, it's basically on age that you retire. So it's known not months, years before where each judge is going to retire.
Yeah, you can probably tell how many vacancies you will have in next decade.
That's right.
Yeah.
I mean, unless, okay, the rare exception is if a judge dies. I mean, that would be the exception, or resigns or something like that, which are very, very rare.
Yeah.
So what's the big deal? This is not done. Then what happens is, in a typical court, a judge will give a next date or an adjournment. So first, the listing of cases is non-chronological, not based on any chronology. In my submission, if I go to the smallest village of Andhra Pradesh or Tamil Nadu and ask an 80-year-old illiterate lady that if there is a queue, who should be served first, I think she will say the first, it should be served as per queue.
Yeah.
Okay. This, I think, is elementary. It's not written in the Constitution, not in the laws, but it's elementary fairness, which is not being followed in the courts.
Yeah.
Some people say that, oh, these cases are of different kinds. I accept, but I'm saying this analysis I have done over 12 quarters for 3-year period. And all India. So that kind of averages out. This simple thing is not being done, and judges give dates, give adjournments, give times very arbitrarily. Even if they want to be fair, I'm saying it's a job beyond the capability of any human being.
Yeah. Yeah.
Therefore, my suggestion has been that evolve a computer software, put into it various possibilities, and then the software should generate the next dates and adjournments based on certain fair criteria, where it's not arbitrary.
Yeah, it may not be first come first serve all the time, but at least it can look at some parameters and decide which one should go next.
And therefore, my suggestion is that what courts must accept is that the maximum period for any case in a court should not be more than double the average.
Yeah.
Which sounds a fairly fair system.
Yeah.
And a computer software could do it very easily. Only thing is, it would take away from the judges' right to arbitrarily decide. And my suggestion is, some people say there are urgencies, so I'm saying, okay, we can fix a limit of maybe 5% and say a judge can override the computer program in 5% cases.
Right, exactly, yeah.
Which is also reasonable. I mean, fair enough. But to treat, and in fact, the Prime Minister's suggestion that all politicians should be fast-tracked falls in the same category of arbitrariness.
Yeah.
Where the common citizens' problems are left out. It doesn't matter.
I think I get a feeling that this is maybe the first step in taking, in taking reforms into the next level, because maybe the government feels that unless they break this Collegium system, unless they get, because now Supreme Court doesn't need to listen to any of this, anybody, right? So the government can make whatever bill they want, but they're not going to get through the judiciary system. So maybe this is
the judiciary may still strike these down.
Yeah.
In my opinion, these are unfortunately power games between the political class and judiciary.
Yeah, and we have seen that
it's not so much about delivering justice.
In UK too, we have seen that several times, that they're going back and forth between the Parliament and the Supreme Court.
So that is a battle between two powerful centers.
Yeah.
Or two sets of powerful people saying, I want more power, the other says, I want more power.
Yeah.
What about justice? What about fairness? And all these are touted as judicial accountability.
Yeah. I know several people that they don't want to go to police because they don't believe in the system. I mean, police itself.
That's right.
But even if a police, by chance, they open a case, they open FIR and they go to court, I mean, that's like a jungle for a common person.
Absolutely.
They don't want to deal with these things. Yeah. They don't want to deal with a lawyer. They don't want to go to court. They don't want to listen to judge. I mean, I'm talking about, like you mentioned, I'm talking about poor people, which is a majority in our country.
I would say poor and even middle class, over 80 to 85% of India's population will not approach a court.
No, yeah.
So what justice system is this? For whom is this justice system that we keep talking of?
Yeah.
The only thing is, okay, Supreme Court at times makes lofty pronouncements. Most of it are not implemented by anybody. So the elite and the richer class seem to feel that we have a justice system, it's a fair system, etc. But for whom? If you are unavailable for 80-85%, if an ordinary person goes there, he's going to be tortured to death by the delays.
Yeah.
We need to question. And my angst is that we are not questioning this. The most fundamental, elementary thing is not being questioned.
Yeah, I really hope this is just the beginning of the reforms. That
there is no sign, my friend. Let me point out. No, I would love to be an optimist, but I am saying unless citizens start raising this as an agenda issue, unless people start clamoring and saying we need this is fundamental to a justice system, it won't happen.
I think we are towards the end of the conversation. I would like you to just maybe point out 3 or 4 things that stands out in terms of the reforms we need. One is the time-bound justice that you mentioned. So could you?
Okay, I'll probably list it if you like.
Yeah.
Number 1, courts must accept discipline that over 95% of the cases will be settled in less than double the average pendency. 2, listing of cases should be done by a computer program with judges having the discretion to override it in only 5% of the cases. Vacancies and sanction strength of judges should be less than 5%. This is another thing which I think we should ensure.
Yeah.
Adjournment should be rare and maximum number fixed by a computer program. Even when an adjournment is given, the next date should be given by a computer.
Yeah.
A calculation can be done to see the number of judges required. In my view, I mean, I've not really calculated. My rough guess is an increase of 20% judges in the high courts and lower judiciary would bring the average pendency down to less than a year, which would mean that all courts in less than 2 years would give judgments. And disposal per judge and court along with data of pending cases giving details of the period since the case was filed should be displayed by all courts on their websites. This is not done.
Yeah, that would be really nice. Yeah.
Basically, a more disciplined judicial delivery system. I mean, instead of assuming that each judge is Lord and God and therefore can do the best. There is no such system in the world.
Yeah. Yeah, you're right. I mean, we're even scared of talking about a judge or a court order. So it's a long way to go, like you mentioned. Unless citizens stand up and say this is what we want, it's going to be a long.
But citizens are so scared and afraid of talking about the judiciary.
Yeah.
It's not funny. I mean, for a democracy, this is not a good sign.
Excellent. Thanks.
Contempt powers also in.
Please go ahead.
Contempt powers in Western countries are very rarely used. In India, it's used far more often.
What is used far more often? Sorry.
Contempt powers.
Yeah.
If you speak against a judge, or speak against a judgment, or as they call, reduce the dignity of the judiciary or their standing in people's eyes, that kind of contempt powers are they are there in Western countries, but they are very rarely used. Very, very rarely.
Yeah.
Whereas here, that is used much more often, and therefore, criticism of the judicial system of this is very, very subdued in India. Everybody just got used to it. Don't criticize.
Yeah, even people in power, even the politicians are scared of the content. So because that's another case of them. So they'll just keep quiet. Yeah. Is there anything that I did not ask and you would like to cover, sir?
No, I just again reiterate at the cost of repetition, citizens, people concerned with India, whether citizens, politicians, even judges, I think, should realize that reasonably time-bound justice is priority one of this nation, and we should all demand that we should find a way. I'm not necessarily saying follow what I am saying. Let's find another method. There will be 100 better methods. But let's make that our agenda number one. Saying this is extremely important. Without this, you will only have illegal actions. You will only have power, people with power being arbitrary. And it continues. Everybody with power in India who is even caught is 100% sure nothing will happen to him in the judicial system.
Yeah.
We need to change this.
Absolutely, sir. Thank you very much for your time. I really appreciate it.
Thank you, Sherry. Have a nice day.
Thank you, sir. Bye.
Friends, if you liked today's show, please go to youtube.com/NRI Samay and click on the subscribe button. You will get notified every time we publish a new show. And you can also like us on our social media sites like Facebook, Twitter, and Google+.